In a last-minute move to present an alibi, attorneys for Bryan Kohberger are now suggesting the man accused of murdering 4 University of Idaho students in November may not have been at the crime scene when the killings took place. In court documents filed Tuesday, the defense writes evidence corroborating Mr. Kohberger being at a location other than the King Road address will be disclosed. And while the defense did not provide further detail about where Kohberger may have been, they say his whereabouts may come to light at a trial through cross-examination and expert witness testimony. Part of the investigation, the discovery of a white Hyundai Elantra that was seen at the crime scene the morning of the murders.
How y'all doing today?
It's the same make and model Kohberger owns, and police stopped him in weeks before his arrest.
Do me a favor and don't follow too close, okay?
This is just the latest attempt to cast doubts on the state's case and the investigation after prosecutors said Kohberger's DNA was a statistical match to DNA found on a knife sheath at the crime scene. Last month, the defense suggested that evidence may have been planted, writing, "The state's argument assumes the DNA on the sheath was placed there by Mr. Kohberger and not someone else during an investigation that spans hundreds of members of law enforcement and apparently at least one lab that the state refuses to name."
Not guilty of the crime of murder.
The filing, reminiscent of another high-profile trial in 1995 when O.J. Simpson's defense claimed a blood-stained glove was planted at their client's home. The jury in that case famously acquitted Simpson. In May, a not guilty plea was entered by the judge on Kohberger's behalf. He faces 4 counts of first-degree murder for the deaths of Kaylee Gonzalez, Madison Mogan, Xana Kernodle, and Ethan Chapin. With this trial set to start in October, the University of Idaho now says it will wait until then to demolish the house where the quadruple killings occurred. The decision comes after the victims' families asked for the house to be preserved.
I don't want somebody in the court case say, well, I really wish we could be in the house right now.
And this new filing is just the latest attempt from Kohberger's attorneys to outline a potential defense. But with a gag order still in place, we may not know many of the details of a possible alibi or defense strategy until the trial starts in 3 months. Guys.
All right, Gadi, thank you. Let's bring in NBC News legal analyst Danny Cevallos. Danny, good morning to you. Okay, so Kohberger's team is saying maybe he was not actually at the house when the murders were committed. We've been talking about this trial for a long time. Why is this just coming to light now? What's the plan here?
Because the rules require them, the defense, to file what's called a notice of alibi. In other words, the rules say that, look, generally a defendant doesn't have to say anything. They can just wait for trial. But when it comes to an alibi defense, especially, this started in the 1920s, people started perceiving alibis as like this last-minute, pull-it-out-of-your-pocket defense. And so out of fairness, the court started saying, well, look, if you're going to say you were somewhere else, you at least have to give the state enough advance notice so they can go out and investigate. If you say you were at your book club meeting, well, then the state should be able to go out and get Ring doorbell tape, talk to the other people at your book club meeting, and generally investigate your claim that you were somewhere else. So this is an exception to the rule, and a controversial exception to the rule, that the defense doesn't need to put on any evidence. And the Supreme Court has said that this is okay with the Fifth Amendment. It doesn't violate the Constitution. This is an exception. You can require a defense to put in this evidence, your notice of alibi. And under the rules in Idaho, this was the time that they had to do it.
To be clear, so far, the defense has not offered any evidence or any witness that would support this alibi theory. So what could the strategy be here from a defense perspective, Danny?
The way I read between the lines of their filing is this, and this is just my take. They're saying, Judge, we don't have alibi witnesses yet, but we don't want to give up the opportunity to present an alibi defense, because the rules of procedure in Idaho and in many other jurisdictions are you either disclose it or you lose it. If you don't disclose a witness at the time you're supposed to, then you may be precluded from calling that witness at trial. So the defense here appears to be trying to hedge their bets. They're saying, look, we may call an alibi. We may have an alibi defense, but we don't have it yet. So, Judge, don't preclude us. And also, Judge, by the way, the Idaho rules allow an exception for the defendant to testify. That means that even if they don't put on any alibi defense or notify them as they're supposed to, they could, in theory, call the defendant, and he could come up with an alibi defense all by himself.
All right, Danny, thank you so much for your insight. We appreciate it.
Danny, thanks.
Hey, thanks for watching. Don't miss the Today Show every weekday at 11 a.m. Eastern, 8 Pacific on our streaming channel, Today All Day. To watch, head to today.com/allday or click the link right here.